Waqf Amendment Bill 2024. For the first time in the history of lawmaking on Waqf, a bill was presented in the Lok Sabha on 6 August 2024 without field study or any inquiry report on the working of Waqf. Lok Sabha sent the bill to the Joint Parliamentary Committee, that is JPC. The committee is expected to ascertain the facts on the ground. It is being said that the committee has prepared a report of 500 pages within a short period of 6 months. In the past, the committees had taken years to do this work. It is giving rise to many suspicions. Let us hope JPC has ascertained whether shortcoming is in the law for which the amendment is required, or it is the failure of the central and state governments in implementing the Waqf Act, and that is the cause of mismanagement. The actual cause, if any, needs to be determined. Without that, the JPC will not do justice to the work assigned to them. Prior to this bill, all legislations beginning from the Regulation 19 and 37 of the Code of 1793 regarding La Khiraj or rent-free land were based on solid facts. The statement of objects and reasons of the Bill 2024 has provided vague reasons and has failed to section-wise justify the amendments. The bill is based on the assumption that the mismanagement in Waqf is due to flaws in the law for which massive amendment in the Act is required. JPC must examine whether the mismanagement in Waqf is due to shortcoming in law or because of failure of the state and the central governments in implementation the Waqf Act 1995. No law can give desired results if proper mechanism for its implementation is not in place. Without a study of the implementation of the Waqf Act 1995, a tall claim in the statement of objects and reasons has been made by saying, quote, "It has been observed that the Act still requires further improvements." Quotes close. Therefore, some of the examples are being presented here. Number 1, Survey of Waqf. The Waqf Act 1995 mandated the state governments to appoint survey commissioners for survey of Waqf in their respective estates. No state has completed and notified the survey in the last 28 years. Earlier, JPC had observed that some of the estates, even survey commissioner was not appointed till 2012. Therefore, the Waqf Amendment Act 2013 said, quote, 3(1)(a), every state government shall maintain a list of Waqf referred to it subsection 1, and the survey of Waqf shall be completed within a period of 1 year from the date of commencement of Waqf Amendment Act 2013 in case such survey was not done before the commencement of the Waqf Act 2013. Provided that where no survey commissioner of Waqf has been appointed, a survey commissioner for the Waqf shall be appointed within 3 months from the date of such commencement. As per our information, no state has notified the survey report till date. If states have failed to comply with the mandate of the Parliament, then the present JPC may call for the reason thereof. In the absence of survey, all data presented by the government are outdated and fictitious. All data quoted in public in this regard are doubtful. This has created great confusion in digitalization, in which one unit is shown in multiple units. Survey is a specialized work of Revenue Department. Computer experts doing the digitalization are not competent to do this. Digitalization before survey is putting the horse before the cart. In this, how can the law and the Waqf board be effective? The central government does not have any explanation for its failure to monitor and direct the estates. The statement of objects and reasons is silent on this. It has simply proposed to transfer the survey to collectors who are already busy in the district administration. This collector Raj is reminiscent of the East India Company days. During the tenure of Lord Cornwallis, Regulation 19 and 37 of the Code of 1793 directed the Lakhrajidars, rent-free landholders, to get their deeds registered in the collector's office within 1 year. Remember, now the proposed bill has stipulated only 6 months for this work. The regulation of 1793 made the unregistered deeds inadmissible as evidence after the expiry of the stipulated period of 1 year, and resultantly liable to ejection. The collectors were tasked to file lawsuits in the ordinary courts against such Lakhrajidars. To induce the collectors, they were offered 25% commission out of the first years of revenue of the recovered properties. The Regulation 2 of 1819 empowered the collectors to act both as prosecutor and judge. It overburdened the collectors. They were not capable of handling such a huge volume of work. In Bardhawan district, for example, 72,000 deeds were presented for registration. Out of that, 4,000 to 5,000 could be examined within the stipulated period determined by them. However, the greed of the collectors led to absorption of small Lakhrajidars by the landlords of Bihar and Bengal. Despite being conscious, the court also did not do anything effectively to stop injustice to the Lakhrajidars. By 1850-51, the situation became alarming, and government slowly became apprehensive of the discontent. Therefore, in 1852, the proceedings were closed. However, by then, the Lakhrajidars had become paupers, and the institution run out of the income of Lakhraj land were mostly closed. One can imagine what will happen if collectors are empowered by the bill 2024. It is bound to create havoc. The Muslim community will be ultimately loser. This is not being done in case of other religious endowments. Only in case of Waqf, this failed experiment of the company era is proposed to be repeated. The present proposal of the government control on Waqf by empowering district collectors also reminds us of the Bengal Charitable Endowment Public Building Regulation 19 of 1810 and Regulation 7 of Madras Code in 1817, through which the general superintendence of all religious and charitable institutions in the two provinces was brought under district commissioners, subject to the control of Board of Revenue of the state. In the Bill 2024, there is no control on the collectors. Collectors is all powerful to decide the matter. Naturally, he cannot afford to the displeasure of his political masters and is bound to act accordingly. Now, another example. Waqf rules. Under Section 109(1) of the Waqf Act 1995, it provides the quote, the state government may by notification in the official gazette make rule to carry out the purpose of this act other than those of chapter 3. Rule relating to Central Waqf Council. The rules thus made shall be laid before the state legislature under section 3. In most of the states, rules under Waqf Act 1995 were not notified for more than 2 decades. The Waqf boards were made to work under the old rules notified under the Repealed Act 1954. There is no saving clause in the Waqf Act 1995 that the rules made under the Waqf Act 1954 will continue till the new rules are notified. Who is responsible for this illegality? As for the information in the public domain, Waqf rules under the Waqf Act 1995 has not yet been notified in Uttar Pradesh, both Shia and Sunni, Madhya Pradesh, Jharkhand, Delhi, Dadar Nagar Haveli, Andaman Nicobar and Lakshadweep. The union territories are directly under the central government. Some of the states like Gujarat, Madhya Pradesh and Meghalaya notified the rules last year in 2023. The absence of new rule caused hurdle in the functioning of the Waqf boards. It is necessary to fix the responsibility. Regulations. Similarly, under Section 110(1), the board may, with the previous sanction of the state government, make regulation not inconsistent with the act or the rules made thereunder for carrying out its function under this act. If rules have not been notified, how can Waqf board prepare regulation consistent with the rules? Previous sanction of the state government is also required. It is observed that the state governments keep pending the draft regulations submitted by the Waqf boards for years. Absence of rules and regulations adversely affects the functioning of the board. Chief Executive Officer of the board. The Chief Executive Officer, that is CEO, plays key role in the functioning of the board. Under the Act, number of executive powers are vested with the CEO. This responsibility cannot be fulfilled with the additional charge given to some officer. Therefore, in the Waqf Amendment Act 2013, it was categorically said in Section 23(1), quote, there shall be a full-time Chief Executive Officer of the board who shall be a Muslim and shall be appointed by the state government. Close. Despite that, the Waqf boards do not have full-time CEO. Most glaring example is of Delhi Waqf board, where Lieutenant Governor appointed by the central government is the ultimate authority. Now, a view may be taken whether the inefficiency of the board, if any, is due to the shortcoming of the Act or because of the violation of the Act. Audit of accounts of the Waqf board. According to Section 81 of the Waqf Act 1995, quote, the accounts of the board shall be audited and examined annually by such auditors as may be appointed by the state government. Quote close. Similarly, Section 81 of the Act says the state government shall examine the auditor's report and may call for explanation of any person in this regard to any matter mentioned therein, and shall pass such orders on the report as it thinks fit. In the amendment of 2013, it was further added that the state government would forward the audit report along with its order on that to the Central Waqf Council within 30 days of laying of such report in their state legislature. Practically, in large number of states, audit of accounts of the board is not done yearly. When audit of 5 to 10 years is conducted, what order can be passed by the state government after such a long gap? To what extent the board will take corrective measures after receiving audit reports of 5 to 10 years together? What advisory will be issued by the Central Waqf Council? It is because of deficiency of law or inefficiency of the state government that requires to be determined. As per section 46(2) quote, before the 1st July next following the date on which the application referred to in section 36 has been made, and thereafter before the 1st day of July in every year, every mutawalli shall prepare and furnish to the board a full and true statement of accounts in such form and containing such particulars as may be approved by regulation by the board of all monies received or expended by the mutawalli on behalf of the Waqf during the period of 12 months ending on 31st day of March, or as the case may be during that portion of the said period during which the provision of this act have been application to the Waqf. Similarly, as per 47(1), the account of the Waqf having net annual income exceeding 50,000 rupees shall be audited annually, or at least such other intervals as may be prescribed by an auditor appointed by the board from out of the panel of the auditors prepared by the state government. And while drawing up such a panel of auditors, the state government shall specifically specify the scale of remuneration of auditors. Again, the state government may, under intimation to the board, may at any time cause the accounts of any Waqf audited by the state examiner or local funds by other officer designated for that purpose by that state government. The state Waqf board and the state government have power to pass order on the audit report of Waqf. After so many checks and balances, if mutawallis are allegedly corrupt, then it means audit of the account is not properly done well on time, or the board and the government does not pay attention to the audit report. Where is the fault of the law in this? The story does not stop here. The Professor Humayun Kabir, the then minister in charge of Waqf, had addressed DO letter dated 18th January 1965 to the chief ministers, drawing their attention to the authority and responsibility bestowed on them by the Act to guide and control the working of the boards, and their powers to issue general or specific directions, get the annual accounts of the board audited, and in case of losses due to negligence or default of the members, recover from them such losses. Fakhruddin Ali Ahmad and other ministers in charge of Waqf continued to write to the states, drawing their attention towards the above? How many letters in the last 5 years have been addressed by the Ministry of Minority Affairs to the states about the above? Central Waqf Council. The term of the Central Waqf Council expired on 3rd February 2023 and it has not been reconstituted. In the absence of the council, whose advice was considered before presenting the bill 2024 in the parliament? The secretary of the council was relieved on 11th April 2023. Since then, there is no full-time secretary in the council. Additional charge has been given to someone in the ministry. In the absence of council and its full-time secretary who has been performing the task of the council, that is, advising the central government, the state governments and the board on matters concerning the working of the boards and due administration of Waqf. If the center fails to abide by the act, how can they ask the states to appoint full-time CEO in the board? In the absence of the council, did administrative ministry send any advice, direction to the state governments or state boards? JPC is expected to ask this. Both before amendment in 2013, the role of the Central Waqf Council constituted by the Government of India was to advise central government on Waqf matters. The council played its role successfully with limited staff. It did not get any grant for its administrative expenditure. With the amendments in 2013, its role was enlarged to advise the central government, the state governments and the Waqf boards on the matters concerning the working of boards and the administration of Waqf. In the amendments, the inserted section 1A has given the responsibility to the council to issue directives to the state board on such issues and in such a manner as provided under subsection 4 and 5. This was to shift responsibility of the Waqf division of the administrative ministry. With this enlarged role, the council required more specialized staff and grant for its expenditure. This was not fulfilled by the central government. The council has been allowed to cripple under the new burden. Despite empowering the council by inserting subsection 1A in the section 9 of the amendment in 2013 to issue the board on such issues and such manner as provided under the section 4 and 5, the federal relation was kept in view. Provision was made that in case of dispute arising out of the directive issued by the Central Waqf Council under subsection 4 shall be referred to the Board of Adjudication to be constituted by the central government, to be presided over by a retired judge of the Supreme Court. Now, in the proposed amendment bill 2024, the central government in various sections desires to encroach upon the rights and responsibilities of the states. Now, regulating secular activities of Waqf. Section 96(1) of the Waqf Act 1995 empowers the central government to regulate secular activities of Waqf. Section 96(1)(c) asks the central government to review administration of secular activities of Waqf generally and to suggest improvements, if any. Under section 96(2), in exercising its power and function under subsection 1, the central government may call for any periodic or other reports from any board and may issue the board such directions as it may think fit, and the board shall comply with such directions. In the explanation it has been said, for the purpose of this section, secular activities shall include social, economic, educational and other welfare activities. When the bill seeks more power to the central government, it needs to be examined how many times, say in the last 5 years, the central government has called for periodic or other reports from the boards and has issued directions. The Waqf Amendment Bill 2024 has been presented without the due examination of the working of the Waqf Act 1995 and without consultation with the stakeholders. No study has been conducted whether the stated shortcomings are due to law or the implementation of the Act by the government. Therefore, the bill has failed to state the reason for amendment in most of the sections. To be continued in the second part.